Lots of people have asked for some clarity on the new law for divorce in England and Wales, which came about through the Divorce, Dissolution and Separation Act of 2020, coming into force just last week on the 6th of April 2022, which has dramatically reformed the legal requirements and procedure for divorce, dissolution and judicial separation. It retains the sole ground for divorce, which is that the relationship has irretrievably broken down. But it removes the requirement to underpin this with evidence, which previously would have been one of the 5 different facts, such as unreasonable behaviour. This was typically the source of a lot of hostility, lengthy proceedings, and difficult cases and hearings that parties needed to endure. Instead, the law has been changed to replace this with a single provision of a statement that the marriage has irretrievably broken down. And so, just to restate it, there is no evidence required to support the statement that the relationship has broken down. As well as one party being able to initiate divorce proceedings, the new law allows both parties to make a joint application where the decision to divorce is mutual. The law also removes the possibility for one party to defend the decision to divorce. As a result of this, the court will take the statement from one party that the relationship has irretrievably broken down as conclusive evidence that has in fact happened. It will remain possible to challenge proceedings in a limited number of circumstances, typically in matters of jurisdiction, an invalidity of the marriage itself, or other challenges such as fraud or not complying with the procedures. The terminology used throughout a divorce has also been changed. Previously, the petitioner would be the person bringing the divorce petition, will now be referred to as the applicant. The petition itself will be the application. What used to be known as the decree nisi is now going to be a conditional order. A conditional order is normally something that is granted in an interim period pending a final order, and that is the case in this case. What was known as the decree absolute, which was the final document for a divorce, is now referred to as a final order. Previously, if a marriage was nullified, that was confirmed by way of a decree of nullity. That has now been replaced with simply a nullity of marriage order. If parties were previously separated by a judicial decision, this would have been a decree of judicial separation. Now this is referred to as a judicial separation order. What was previously referred to as an undefended case is now a standard case. What was previously referred to as a defended case is now a disputed case, because a case can only be disputed in a limited number of circumstances, as I've set out previously. The legal requirements for a dissolution of a civil partnership or same-sex divorce are broadly the same as those for an opposite-sex divorce, the principal differences being those of jurisdictional criteria. So an application can be made by one party or it can be made jointly. If it's made by one party, it's referred to as a sole application. If it's made by both parties, it's referred to as a joint application. Joint applications have been introduced to encourage parties to cooperate, to reduce the potential for hostility, and of course to reduce costs. However, a joint application may not always be appropriate. For example, if there are existing or pending allegations of domestic abuse. Or, for example, if one party were financially weaker, in which case it might be sensible to have some control as to when a final order is made. Urgent applications can still be made by marking the application as such and making the statement of truth when making your online application as required. In the event of a sole application, the court will send an email notification once the application has been issued by the court, and then the court will produce certain documents that must then be served on the respondent. Once properly served with the application, the respondent must then complete and file, i.e. submit if it's online, an acknowledgement of service within 14 days, and this begins the day after being served with the application. Although the respondent must be served within 28 days after the application has been issued, respondents should also remember that responding with an acknowledgement of service does not necessarily indicate that the application has been disputed, and an applicant may still progress the speed with which a divorce goes through for a conditional order unless the respondent has filed and served an answer. In the case of a joint application, the court will send a copy of the notice of proceedings to both applicants, applying jointly for the divorce. Each applicant is then required to confirm receipt of notice within 14 days. They can do this by logging in and clicking Confirm Receipt on a drop-down menu available on the website. Once both applicants have confirmed receipt of notice of proceedings within 14 days of receiving it, they must then wait 20 weeks from the date of issue, giving them time to think about it in case they change their mind before making an application for the conditional order. The purpose for this period is both for reflection and to try to resolve financial and children matters within this 20-week period. Although the court does retain the power to shorten this 20-week period and the 6-week period between the conditional order and the making of a final order. And finally, with regard to children, parties are of course encouraged to try to resolve issues consensually and amicably between each other, and if not, to embark on mediation. And if parties still cannot agree arrangements, or they've made arrangements and those arrangements keep failing, then one party or another can apply for a relevant order under the Children Act, and of course you should seek formal legal advice in respect of this application also. And of course, with any of my videos, this is a general outline and guidance, and you should always seek formal legal advice if you are still unclear after reading the official websites and guidance as to how to proceed. But I hope this addresses many of the questions, so please do like and subscribe, and as always, thank you for watching.